and the whole House will be sorry to hear about what has happened. Thank you. The clerk will now proceed to read the orders of the day.
Safety of Rwanda, Asylum and Immigration Bill, consideration of Lord's message.
Now,
before we move to consideration of the Lord's message, I can confirm that nothing in the Lord's message engages Commons financial privilege. We will begin with the government motion to disagree with Lord's Amendment 1B, with which we will consider the other government motions as listed on the selection paper. I call the Minister to move the motion to disagree with Lord's Amendment 1B. Michael Tomlinson.
Thank you, Madam Deputy Speaker, and I beg to move that this House disagrees with the Lords in their amendments. Madam Deputy Speaker, here we are back again debating the same issues and amendments that we have already rejected. We're not quite at the point yet of completing each other's sentences, but we are almost there. The issue before the House is whether the clearly expressed views of this House throughout the entire passage of the bill should prevail. We simply cannot accept amendments that provide for loopholes which would perpetuate the current cycle of delays and late legal challenges to removal. We have a moral duty to stop the boats. We must bring an end to the dangerous, unnecessary and illegal methods that are being deployed. We must protect our borders and, most importantly, save lives at sea. Our partnership with Rwanda is a key part of our strategy. The message is absolutely clear. If you come to the United Kingdom illegally, you will not be able to stay. You'll be detained and swiftly returned to your home country or to a safe third country, Rwanda. I won't give way. On the issue of Amendment 1, the use of a Section 19(1)b statement does not mean that the bill is incompatible with the European Convention on Human Rights. There is nothing improper or unprecedented with such a statement. It does not mean that the bill is unlawful or that the government will necessarily lose any legal challenge. These statements have been made in the past, including in 2003 under the last Labour government. We have a long-standing tradition of ensuring that rights and liberties are protected domestically and of fulfilling our international obligations, and we remain committed to that position. Our focus is on passing this legislation that will deter people from entering the country dangerously and illegally. Turning to the revised amendments on the implementation of the treaty and the role of the monitoring committee, Clause 9 of the bill clearly sets out that the bill provisions come into force when the treaty enters into force, and the treaty enters into force when the parties have completed their internal procedures. Amendment 3B confuses the process for implementing the treaty with what is required for the bill provisions to come into force. As I've said before, the treaty enhances the role of the previously established monitoring committee, and the monitoring committee will ensure obligations to the treaty are adhered to in practice. Madam Deputy Speaker, it was always intended for the monitoring committee to be independent. Maintaining the committee's independence is an integral aspect of the design of the policy, and Amendment 3C risks disturbing that independence and impartiality. The government will only ratify the treaty once we agree with Rwanda that all necessary implementation is in place for both countries to comply with the obligations under the treaty. That being the case, there is simply no need for this amendment. Despite the refinements made, Amendment 6B is still a wrecking amendment which seeks to reverse the bill's intent. The purpose of the bill is to invite Parliament to agree with the assessment that the Supreme Court's concerns have been properly addressed and to enact the measures in the bill accordingly. This bill reflects the fact that Parliament is sovereign and can change domestic law as it sees fit. The evidence that we have provided and the commitments made by the government and the government of Rwanda through this internationally binding treaty shows that Rwanda is in fact a safe country and enables the bill to provide for Rwanda to be deemed a safe country. Madam Deputy Speaker, as I'm sure those who support and vote for this amendment know, the amendment would render the bill utterly pointless and would not enable us to create the deterrent that we need to stop the boats and get flights off the ground. Turning to Amendment 7B, we know assessing age is inherently difficult, but it is important that the government takes decisive action to deter adults from knowingly claiming to be children. There are obvious safeguarding risks of adults being placed within the care system. It is crucial that we take steps to safeguard children and avoid lengthy legal challenges which prevent the removal of those who have assessed to be adults. This amendment would result in treating those who are to be removed to Rwanda under the Illegal Migration Act differently from those removed to another country under the very same Act. There is simply no justification for this differential treatment. I'm going to make some progress. Amendment 9 undermines provisions in existing legislation and is completely unnecessary. It is vital that the government takes steps to reduce or remove incentives for individuals to enter the country illegally. These illegal practices pose an exceptional threat to public order, risk lives, and place unprecedented pressure on public services. As I have previously set out, under Article 13 of the treaty, the Government of Rwanda will have regard to information provided relating to any special needs an individual may have as a result of them being a victim of modern slavery. Rwanda will take all necessary steps to ensure that these needs are accommodated, and to that end, the government has tabled Amendment A in lieu. This requires the Secretary of State to publish an annual report about the operation of the legislation as it relates to modern slavery and human trafficking provisions. And with that in mind, I'd invite the House to reject the Lords' Amendments 9 and agree with the amendment in lieu. In relation to Amendment 10B, as I've previously set out, this government recognises the commitment and responsibility that comes with combat veterans, whether our own or those who showed courage by serving alongside us. We will not let them down. Once again, I want to reassure Parliament that once the United Kingdom's Special Forces ARAP review has concluded, the government will consider and revisit how the Illegal Migration Act and removal under existing legislation will apply to those who are eligible as a result of the review, ensuring that these people receive the attention they deserve. This is a commitment that both the noble Lord, Lord Sharp, and I have made on behalf of His Majesty's government. Madam Deputy Speaker, the elected House has voted to give the bill a second and third reading and voted down each of the Lords' amendments. I invite all right honourable and honourable members to stand with the government in upholding the will of the House of Commons and to support the government motions.
The question is that this House disagrees with the Lords in their Amendment 1B. Shadow Minister Stephen Kinnock.
Thank you very much indeed, Madam Deputy Speaker. Well, it's just over 2 years to the day almost since the Rwanda scheme was first announced from that dispatch box. So it would be remiss of us not to take stock of progress to date. Well, hundreds of millions of pounds of taxpayers' money have been sent to the Rwandan government. Civil servants, courts, parliamentarians and journalists have spent countless hours, days and weeks discussing and writing about it. And not one, not two, but 3 Home Secretaries have been flown down to Kigali. But apart from that, I have to say there's not a great deal to report, Madam Deputy Speaker. The boats have kept coming, the backlog has kept growing, and the people smugglers are still laughing all the way to the bank. 2 years of headline-chasing gimmicks. 2 years of pursuing a policy that is fundamentally unworkable, unaffordable and unlawful. 2 years of flogging this dead horse. Madam Deputy Speaker, I am an inveterate optimist, so I truly believe that one day the benches opposite will come to understand that hard graft and common sense are always more effective than the sugar rush of a tabloid front page. And they will come to accept that they should have adopted Labour's comprehensive plan to restore order to our border by redirecting the vast amounts of money set aside for the Rwandan government into a new cross-border police unit and a new security partnership with Europol to smash the criminal gangs upstream. Analysis conducted by the National Audit Office has revealed that if the government manages to send 300 asylum seekers to Rwanda, which is just 0.5% of the 60,000 people currently earmarked for the scheme, then it will cost the British taxpayer a truly staggering £2 million per person. Now, it is crystal clear that the scheme is doomed to fail on its own terms because people who are prepared to risk life and limb crossing continents are not going to be deterred by a 0.5% chance of being sent to Rwanda. But, Madam Deputy Speaker, the mind-boggling costs of the scheme are quite difficult to grasp. So I've done a bit of homework, a bit of research into what else you could get for £2 million. Now, my honourable friend, the member for Bermondsey, who's not in his place this evening, got the ball rolling on this one by pointing out that during our last debate on this bill, the £2 million will get you 5 trips to outer space on the Virgin Galactic spacecraft. But I've calculated, Madam Deputy Speaker, you look impressed, and suitably so, but I've calculated that you can live for 3 decades on one of the world's most expensive cruise liners. You could charter the Lady M yacht for a year. That is, of course, the yacht that belongs to the noble Baroness Mones. It's her vessel of choice, as some of those on the opposite benches may be aware. Or you could even fly the Prime Minister's favourite helicopter to Australia and back. And speaking of the Prime Minister, I noticed that during the Easter recess, he found time to offer his services as a financial advisor to small businesses via Zoom. Well, I don't know about you, Madam Deputy Speaker, but I have to say I do have some concerns that the guy who's happy to pump billions of pounds into a failing fiasco like this Rwanda scheme is offering his services as a financial advisor to unsuspecting members of the public. Let's hope the Financial Conduct Authority will intervene as a matter of urgency. I will take an intervention.
Very grateful to the honourable gentleman. He's proving to be most entertaining. But as this is consideration of Lord's amendment, is he going to actually get on to deal with the amendments?
Which one?
I want him to be in order.
Order! If the honourable gentleman was not in order, I would not have allowed him to speak. He has been drawing some very interesting facts to the attention of the House, and I, for one, am likely to explore some of them, but not the yachts. Mr. Kinnock.
Thank you very much, Madam Deputy Speaker, and I always enjoy taking interventions from a fellow Welshman, but I do feel he was well and truly put into his place by that particular riposte from Madam Deputy Speaker.
From a non-fellow Scotsman.
I will take an intervention.
I'm grateful to him. I'm sure that he, like me, will have marvelled at the government's ability to legislate for Rwanda to be a safe country. And this, of course, is in respect of Lord's Amendment 2, Madam Deputy Speaker. So will my honourable friend join me in urging the government to use this amazing power that it has to legislate that CO2 emissions will no longer cause global warming and that sugar, fat and alcohol will no longer damage human health?
Well, I thank my honourable friend for that intervention. I'm sure the benches opposite would be delighted to oblige, and perhaps we could also legislate that the sky is green and the grass is blue, or perhaps that the Welsh rugby team actually won the last Six Nations. I would love to pass a law to secure that objective. Turning now to the amendments that are before us today. Let's be clear, not one of these amendments prevents flights from Rwanda taking off. On the contrary, they simply seek to place on the face of the bill what ministers have previously promised, namely that the bill is lawful, that the government will protect the most vulnerable, and that we will stand by those brave Afghans who have supported military efforts. Addressing each amendment directly, Madam Deputy Speaker, I'd like to first focus on Lord's Amendment 10B in the name of the noble Lord Brown. Now, we have spoken a lot about the unworkability and the unaffordability of this policy, but we should also talk about the unethical and frankly un-British nature of deporting Afghans who have supported Britain's defence and diplomatic efforts halfway across the world to Rwanda. Yeah. That is not Operation Warm Welcome, Madam Deputy Speaker. That is Operation Cold Shoulder. And we should have seen it coming. Given the Prime Minister halted flights from neighbouring Pakistan for an entire year for Afghans who had already been granted resettlement rights in the UK under ARAP, and only restarted them when the Pakistani government threatened to send those Afghans back across the border to meet their fate in the hands of the Taliban. We owe a debt of honour to the loyal to Britain Afghans who put their lives on the line. And of course, our moral duty is most strongly felt by British Armed Forces personnel who worked alongside them. In fact, this weekend, 13 senior military figures signed a letter to the Sunday Telegraph warning that any brave men and women who have fought alongside our armed forces or served the UK government overseas must be exempt from removal to Rwanda. The signatories included former chiefs of defence staff, as well as a former Secretary-General of NATO and a former Deputy Supreme Allied Commander Europe. They warn that if this exemption is not granted, it will do grave damage, I quote, do grave damage to our ability to recruit local allies in future military operations. And they explain, and I quote again, that they have seen firsthand the enormous courage and dedication shown by those who have fought alongside our armed forces and served British interests abroad, often at huge personal risk. And we take personally Britain's obligation to honour the debt we owe to that cohort. Powerful words indeed, Madam Deputy Speaker. Yep. And I would therefore urge the benches opposite to join us in supporting Lord's Amendment 10B this evening, which seeks to prevent this travesty.
Kevin Foster.
Minister for giving way. The key issue, as he and I will know, is not about Arab people coming via small boats, but unbunging the resettlement programme. In that sense, and given the remarks he's just made, how many spaces does he envisage ensuring are available for resettlement under that scheme?
Well, we know that a number of those who served the British defence, development and diplomatic efforts have been identified for resettlement. So what I would say to him is that those people should be being resettled in the United Kingdom. Let's get that bit of this scheme unblocked before we get into speculation about the quantum, because the key point here is they have already been accepted into the resettlement programmes, but they are being left high and dry in Pakistan.
Madam Deputy Speaker, my honourable friend was accused of levity earlier, but this House has so many things to discuss. There are good policies and sensible, workable policies to deal with unchecked migration. He knows that, I know that. But this, the Rwanda scheme, reminds me, and he probably too young to remember, the Monty Python dead parrot sketch. This scheme is a dead parrot, and the sooner this government wakes up that it's dead, the better. Yeah.
Well, I thank my honourable friend for that point, and he is right that there are so many practical, pragmatic and sensible measures that could be taken to deal with the crisis in the Channel, the Tory small boats chaos. But instead of focusing on those sensible, pragmatic measures, we are dealing with this white elephant of a programme that is never going to get anywhere and is costing millions of pounds of taxpayers' money and absorbing huge amounts of our time. I agree with him absolutely on that. Now, Lord's Amendment 9B, in the name of the noble Baroness Butler-Sloss, is also based on a moral imperative, as it would prevent the removal of potential victims of modern slavery to Rwanda until the individual's process under the national referral mechanism is complete. Now, it should go without saying that modern slavery victims should not be being sent to Rwanda, and we are disappointed that the government's amendment in lieu on this one is a profoundly unserious attempt to reassure the House, not least because we've been here before, and we know that these promised reports are rarely worth the paper they're written on. We on these benches are also deeply concerned about unaccompanied children being inadvertently sent to Rwanda. We therefore support the noble Baroness Lister's Lord's Amendment 7B, which recognises the government's reasoning for rejecting her previous amendment, by this time proposing that an age-disputed person who is appealing their decision can only be removed to Rwanda if a local authority has agreed and stated that this person is not a child. Now, the other Lord's amendments all relate to the rule of law, and we support all of these amendments, which simply articulate principles with which ministers have said from that dispatch box that they agree. The simple question is, Madam Deputy Speaker, if ministers believe that Rwanda is a safe country, then why is the government refusing to support these amendments? They say that this bill abides by international law. So why not just make that clear on the face of the bill? They say that Rwanda is capable of meeting its obligations under international law. So let's see the evidence and let's agree a trust but verify mechanism as set out in these amendments.
I thank my friend for giving way. Would he agree that this bill is not only just inhumane, costly and unworkable, but despite the best efforts to amend the bill, the legislation, the Tories seem resolute in pursuing it rather than getting to grips with our broken asylum system? Just another indication to the country that this government is unfit to govern.
Well, I thank my honourable friend for that intervention, and I think there's a very clear choice between the common sense and hard graft and positive international cooperation that is set out in Labour's plan to deal with this issue, and the headline-chasing gimmicks and empty gestures that are symbolised by this Rwanda policy. Politics is about choices. The government's taken its choice, and we have taken ours. So in this spirit, Lord's Amendment 1B is a Labour frontbench amendment which places a responsibility on the government to have due regard for its current obligations under domestic and international law. Lord's Amendments 3B and 3C, in the name of the noble Lord Hope, together state that Rwanda may only be considered to be a safe country if and when the measures set out in the Rwanda Treaty have been fully implemented and when the Monitoring Committee has established that this is the case. The government claims that the measures in the treaty address concerns in the Supreme Court's recent unanimous ruling. So there is absolutely no reason why ministers should refuse to accept Lord Hope's amendments. Finally, Lord's Amendment 6B, in the name of the noble Baroness Chakrabarti, allows government ministers, officials and courts to consider whether Rwanda is safe on a case-by-case basis. Given that the government has accepted that some appeals will be allowed, we see no reason for the government to reject this amendment. Madam Deputy Speaker, I hope that colleagues across this House will join me and these benches in voting to support all of these amendments this evening. But of course, these amendments are no more than an exercise in damage limitation, because the fundamental problem is that this harebrained Rwanda policy is breaking all records for being the most unworkable and the worst value for money policy in the history of the Home Office. But there is an alternative, Madam Deputy Speaker. In addition to our policy to go after the criminal smuggler gangs, we will also deliver our backlog clearance plan to get asylum seekers out of expensive asylum hotels by surging decision makers and caseworkers to the Home Office and by creating a new returns and enforcement unit with 1,000 dedicated staff focused on the faster removal of those with no right to be here, including failed asylum seekers and foreign criminals. Madam Deputy Speaker, the benches opposite are failing on all fronts. Despite their misleading boasts about progress, the Immigration Minister today admitted that there are still almost 300 asylum hotels in operation. They are returning 44% fewer failed asylum seekers compared to the last Labour government leaving office in 2010 and 27% fewer foreign criminals. The number of small boats crossings has gone up again year on year, January to March, and they have no plan for the 99% who cannot be sent to Rwanda. So we need Labour's plans to smash the criminal smuggler gangs, save lives in the Channel and strengthen our border security. We need Labour's plan for faster processing, the end of hotel use and the removal of people who have no right to stay in the UK. And we need a Labour government to deliver a firm, fair and well-managed asylum system that works for Britain. Thank you.
Sir William Cash.
Madam Deputy Speaker, I don't really feel that there's anything terribly useful I can say at this stage. I've heard all this, I've heard all this before. The honourable member who speaks from the front bench is simply repeating what he said before. And not only that, perfectly apparent that these amendments are just wrecking amendments. And thirdly, the fact is he doesn't even address the arguments about international law when he knows perfectly well, because he can't answer my questions on this, that we have a dualist system, and if we decide to legislate in our own legislative way, in our own courts, in our own parliament, the courts themselves will implement that legislation. So the real question now is, let's get this bill done. Let's get the House of Lords to calm down a bit. And let us also, at the same time, wait for what is inevitably going to be another claim, and then see what the judgment of the Supreme Court is on the wording, providing it is clear and unambiguous, of this bill. That's all I need to say. I may come back again, however, if there is another insistence by the Lords on these ridiculous amendments.
SNP spokesman Alison Thewliss. Thank you very much, Madam Deputy Speaker. Well, here we are again debating this outrageous and unworkable bill. We're no further forward, and the government will fail to get any further forward, really, because this is a complete waste of time and money. It is a ruse only to get tabloid headlines, and I'm not even sure at this stage if they have any intention that this plan will actually work at all, given the incompetence that they've showed so far. They are scrabbling around this week trying to find airlines, because not one single responsible air carrier wants to be associated with the government's state-sponsored people trafficking plans. They've been trying to find other countries that they can try and send places to as well. Armenia and the Ivory Coast and Costa Rica or Botswana might be interested, but far, far more countries rather sensibly told them to go and get raffled. And I'm not convinced that even Rwanda believes that this plan will work, or that people will be sent, because they've gone and sold off the housing that they built, that the former Home Secretary so admired. So, in fact, if they do send people, there's not even going to be the facilities to put them in, unless the government intends to stack them high, as they do often in hotels in this country, treating people as human cargo that they can so easily dispose of. It is absolutely despicable. And so far they've sent Home Secretaries, they've sent civil servants, even the Joint Committee on Human Rights has gone to Rwanda, along with some hand-picked journalists, and yet no asylum seekers, and nor is there much prospect of them going. And yet, while all of this has gone on, dozens of Rwandans have actually submitted asylum claims here in the UK. And in Rwanda itself, there is still concern over Rwanda's sponsoring of the M23 rebels, who are engaged in conflict with their neighbours, the Democratic Republic of Congo, last month, wounding UN peacekeepers in the DRC and controlling roads and mining sites in the DRC, displacing 1.7 million people. And Vava Tampa in The Guardian last week has questioned international support for the Kagame regime. Vava Tampa says, the UN, Human Rights Watch and Amnesty are clear that without Rwanda's backing, the M23 couldn't have killed, raped, tortured and displaced as many as it has. So I would ask the government why it wants to pursue deals with such a regime. It is quite worrying indeed. Moving to the Lord's amendments, I will go through them in turn. And the first of the Lord amendments asks that the government have due regard for domestic and international law. Well, yes, that should be a basic of any legislation that this House wishes to pass, due regard to domestic and international law. Now, this waters down slightly the previous amendment about maintaining full compliance with domestic and international law. Clearly too hard an ask for the government, even to having due regard to domestic and international law is too much for this government, clearly. Obligations like the ECHR, which is tied up with the Good Friday Agreement, with the devolution settlements in this country, international law, the Refugee Convention, the UN Convention Against Torture, the UN Convention on Civil and Political Rights. Now, why would the government not want to abide by these international agreements?
I thank my friend for giving me for all the points that she's making. Isn't it a concern that if the UK government thinks it can just ignore all of these international commitments to which it has already been signed up, in fact, which it already helped to found, such as the ECHR, how on earth can it then turn around to other how on earth can it turn around to other countries who might be breaching their international obligations under international law and say that they should comply with these treaties?
hypocrisy goes even yet further than just that. They expect Rwanda to uphold all of its agreements internationally and domestically, and its laws internationally and domestically, while specifically setting out to breach its own laws here and its own obligations here in this legislation. It is absolutely ludicrous. Moving to the next of the Lord Amendments 3B and 3C, they ask that Rwanda will be a safe country when the arrangements provided for in the Rwanda Treaty have been fully implemented and for so long as they continue to be so. And I think this question of how long they continue to be so is just as critical as whether they meet the measures just now, because what this government is legislating is that Rwanda is safe forever, in perpetuity, in this legislation. Nobody can say that of any country in the world at any point. So to legislate specifically that this country uniquely should be safe forever and ever is really quite bizarre in this legislation. And I think it's quite reasonable, really, of the Lords to say that the Rwanda Treaty will cease to be treated as fully implemented if Parliament decides, in the advice of the Monitoring Committee, that the provisions of the treaty are no longer being adhered to in practice. And there should be a check on that. The government should not fear that. If it believes truly and deeply that the agreement will be adhered to, surely there is no harm in scrutinising that agreement. But yet the House of Lords International Agreements Committee has said that the treaty is unlikely to result in fundamental change in the short term. And the UK Supreme Court pointed out in its judgment at paragraph 87, I believe, that Rwanda refouled at least 6 people while the treaty was under negotiation. Now, if this does not raise alarm bells to the government about the ability of Rwanda to adhere to this treaty, I don't think anything will. Moving further to 6B, and I think this really is when it comes to actually some of the domestic law, and it's not about international courts and foreign judges as if that was a bad thing and we don't actually send people to sit on that court ourselves. It's about the integrity of our own courts and tribunals and of UK-based judges and decision makers that the Home Office employs to do their job, which this legislation undermines. And the amendment says that Section 2 does not prevent the Secretary of State or an immigration officer from deciding whether the Republic of Rwanda is a safe country for the person in question or her groups of persons to which the person belongs. And I think that is quite reasonable. We should look at the evidence before coming to decisions. And this is asking for the courts and tribunals to be able to do their job, not to ignore the evidence, not to engage, as others have described, in a legal fantasy, that they cannot look at the evidence, they cannot see, that they cannot hear, that they cannot speak out about what they know to be true. And I think that is quite unreasonable. And if he thinks that our own domestic judges should not be allowed to make decisions on this, I'd be very interested to hear his point.
If I may, Madam Deputy Speaker, that if you look at Section 57 of the Immigration Bill, the Immigration Act to which he refers, 2023, what it does say is a perfectly reasonable point, which is that the courts must take account of the facts. That is the key question. I didn't hear her say that because that is something which is indisputable and, in my opinion, unassailable. If, with regard to the question of age or any other matter which falls within the framework of this particular amendment, there was a question of fact, then surely it must be the case that the courts should be entitled to deal with facts, but not to deal with the questions that the Honourable Lady has just been referring to.
Well, this legislation inhibits the ability to look at facts, and I think that's really quite a dangerous road to go down, and I don't think that is really what the government ought to be doing in any circumstance. No matter how much they might wish their will upon the courts, they should not be doing this in legislation. It is completely wrong. Turning to 7B on the age assessment of unaccompanied children, and this again asks quite reasonably that there should be that a relevant authority, a local authority, should have an expert assess carry out an age assessment on people that they consider to be children. The Children's Society have repeatedly said that they see unaccompanied children being incorrectly assessed by immigration officials to be adults on arrival in the UK. So I think calling for a proper assessment here is perfectly reasonable, rather than sending children off to Rwanda and then trying to retrieve them later. The harm that that could cause is really quite significant. And in the government's own figures, in the first 6 months of 2023, 485 children were wrongly assessed to be adults. And the Home Office gets this wrong quite regularly. Headland Bamber's Foundation has found that over an 18-month period, 1,300 children were as wrongly assessed to be adults, the majority being incorrectly assessed. So the government really needs to admit that it does get this wrong, and that it shouldn't be sending children to Rwanda and then trying to retrieve them at some stage later if, oops, somehow we got it wrong. Do it properly, do the assessment at the beginning, rather than causing young people who have already suffered a huge amount of trauma yet more pain. Moving to Lord's Amendment 9B and their insistence that 9B be considered again on the removal of victims of modern slavery and human trafficking. And again, this is hugely significant. This goes against our obligations on human trafficking, and we should not have a government sending people who have been trafficked away with a significant risk that they may be re-trafficked or going through yet further trauma, and the impact that that will have on their physical, mental and health and safety. And I think that is something that the government really ought to be considering. Why wouldn't you want to consider the risks of people who have been trafficked? And the Modern Slavery and Human Rights Policy, the Evidence Centre from the Bingham Centre for Rule of Law, have done significant work on this. And I would ask the House to consider their evidence on this, about the breach of our obligations that the government is embarking upon. I think it is absolutely wrong that they should seek to do this to people who have been already through so much. And finally, moving to...
It's a good point, because vulnerable people are already being targeted by the government on a voluntary basis. But I had a young man in my constituency recently with severe health problems who the Home Office tried to persuade to voluntarily go to Rwanda, severely traumatising for them. That for somebody who suffered previously in coming to the UK, from what the experiences they've had in their home country, to then have that degree of what they perceive as pressure, possibly bribery as well, happening in that sense, is extremely traumatising. If this is the way the government is going, then these amendments are essential.
With many of my constituents and with other people who have been victims, as he sets out, this is devastating for them. It's already difficult enough to escape from your traffickers. It's already difficult enough to speak out about this, to have your case believed by anybody. But Article 13 of the Rwanda Treaty, which would allow the UK to never conclusively determine whether a potential victim of modern slavery is indeed even a victim, would put the UK in breach of its Article 4 HCHR and Article 10 ECAT obligations to identify and assist potential victims of modern slavery and human trafficking. And by tying it up with the immigration system and the way that they have, again, that undermines people's rights and undermines our obligations as the UK to do this. I absolutely pay tribute to the Modern Slavery and Human Rights Policy and Evidence Centre for the evidence that they have sent to members. If it's in your inbox, please read that before you vote on this bill and on this particular amendment. And moving lastly to the exemption for allies, agents and employees of the UK overseas. Now, it remains the case that many Afghans have come here on small boats because the UK government schemes have failed. They have failed to protect people, they have failed to bring people who served alongside British forces in Afghanistan, people to whom they put their trust in the UK to protect them and their families. They put their trust in the UK-US project in Afghanistan, and that trust has been thoroughly breached. And I get emails from people quite regularly who feel as though they have been deeply let down by the UK government. That trust has gone. And by putting in this exemption to the bill, that at least gives some prospect of there being some degree of trust in future. Because at the moment, if I was in some country that the UK became involved in, the last thing I would want to be doing now is getting involved with UK forces, because as soon as the UK ships out, you're on your own. Too bad. Tough. It is a death sentence for those people that put themselves forward to help and support UK objectives overseas. And it is disgraceful the way in which this government has treated those people and their families. And as I've said many times before in this place, during the fall of Afghanistan, I had many families who live in my constituency who had relatives and Afghanistan. Very, very few of them ever got out. I don't know what happened to them. I don't know if they're dead or if they're alive, and some of their families may not even know that either. But they have been let down by this UK government. The schemes that the government minister talked about have failed. They are not bringing people to safety. They have failed on the terms that were promised. Whether they will ever meet the number of people that were supposed to come over and get safety here, I seriously doubt at this stage. So at the very least, the government could have a recognition in this bill. At the very least, they could accept such an amendment as this, because they must know that because Afghans are coming in small boats, their schemes, their supposed safe and legal routes have failed. Madam Deputy Speaker, I'm not convinced that this bill will be any kind of deterrent. Already, almost 3,500 people have crossed in small boats this year so far. It has not deterred a single solitary one of them. But what it has done, and what it has made incredibly difficult, is those people that are now considered inadmissible to the system. And I asked the Minister what is going to happen to those, because we know that the very small, tiniest proportion of people, if the government even actually ends up sending them to Rwanda, will be the tip of a massive iceberg of people who are just swimming around in the system now with no rights. And I have constituents coming to my surgeries now who say that they are waiting, that they cannot be dealt with, that they cannot have their asylum claim processed because this government has deemed that they are inadmissible. What happens to them? Where do they live? How do they continue to exist in this country if the government will not process their applications, will not listen to their claims, whether that is through human trafficking or modern slavery, whether that is people who have been victims of torture, whether that is people that have, I'm just coming to the end of my remarks, but the government will not even listen to these people's stories. So what will happen to them and where will they live? Because this government seems to have no consideration for the trauma that people have gone through, and now they leave them in immigration limbo forever in this ridiculous, expensive, unworkable system. The asylum system is broken. We know who broke it. We know that an independent Scotland would treat people far more humanely than this government ever will.
Hear, hear, hear.
David Simmonds.
Thank you very much indeed, Madam Deputy Speaker. Very grateful to the Minister in his opening remarks for setting out in detail the changes and amendments that the Government has made, both in terms of what is on the order paper and what is a matter of approach in response to the concerns that have been raised by many and the points that have been made by many in earlier stages of this debate. So I'd like, Madam Deputy Speaker, in particular to address the points made around Lord's Amendments 1B and 7B, and then just to briefly touch on a couple of other points which have arisen in the debate, which, certainly from my experience in the world of local government, continue to have a relevance and which will need to be addressed in due course if this is going to take effect in the way that we wish to see it take effect. Madam Deputy Speaker, I'm a great enthusiast for the European Convention on Human Rights. And I think it is important to acknowledge in the context of this debate that since this House previously considered and debated this particular piece of legislation, there has been further development in respect of the Rule 39 interim orders. In fact, the various bodies that are concerned with the operation of that convention, including the court, have recognised the concerns that were caused to the UK government and other member states of the ECHR by the way in which those judgments had been handed down, and have confirmed that they will be updating their procedures to ensure that the operation in future is different and in a way that reflects the concerns which were expressed by many in this House. And I see that as evidence both that the ECHR remains a living document, but also that the concerns which the UK government has expressed are being taken seriously. I think many members will have been slightly alarmed, I think, by the recent judgment that was handed down in respect of environmental legislation. I note that the British judge Tim Ike, whose commentary on that particular judgment, which was a dissenting commentary, has been publicised very widely. And he set out in a great deal of detail why many of the issues that have been raised by members of this House in respect of this particular piece of legislation were also relevant in that context, that the risk of perceived overreach, of developing a living document to the point where it went beyond the level of consent which the original contracting parties had in mind, that remained something which the court needed to be alive to. And I'm very conscious that because of the way the Convention operates in practice, that it is an accountable process, accountable to the Parliamentary Assembly, to the Congress, to the Council of Ministers, ultimately to the Member States. That the, of course.
Prime Minister and the former Home Secretary and various others on his benches to continually refer to the European Court of Human Rights as a foreign court?
Deputy Speaker, I know the Prime Minister has made the point that given that the court is based in Strasbourg, certainly in a technical sense it can be described as that. But from my perspective, having served on the Congress, I'm very much aware that it is a court to which the UK, partly through its role in the creation of the Treaty of London, which set up the Convention in the first place, has always been an enormous supporter. And we need to ensure, through the input that members of this House, amongst others, have, through the Parliamentary Assembly and the Council of Ministers, and other parts of the British political family, through things like the Congress have, that we continue to play a part in ensuring it develops in the way that we would wish to see it develop. Of course.
Well, I'm a member of the Parliamentary Assembly of the Council of Europe, and I'm not aware that I'm a foreigner. But it has many difficulties. But I think we're missing the essential point. What concerns me is that in the absence, and I support this bill for what it's worth, but in the absence of these people who land here being detained, if they are threatened with being deported to Rwanda at some stage in the future, they're simply going to bugger off into the community.
Perhaps the honourable gentleman means they might disappear into the community. I think that would be preferable.
I'm using rather colourful phraseology just to make my point, Madam Deputy Speaker, but I take my ticking off.
I'll forgive the right honourable gentleman on this occasion. They will disappear into the community. Mr Simmonds.
Well, thank you very much indeed, Madam Deputy Speaker. I'm grateful for my honourable friend for highlighting that in a way that I'm sure many of our constituents would choose to highlight it as well. But just in order to finish, Madam Deputy Speaker, the point around the Convention itself and Amendment 1B, I think it is absolutely clear, as the Minister said at the dispatch box, that when we cannot be certain of a future potential legal challenge, that it is appropriate that the statement is made as it has been made in respect of this. But it remains, my view, and I think the view of many others, that we have many channels of influence, both diplomatic and political, that this is a living convention. We know that it is embedded in many different parts of our constitution, not just the Good Friday Agreement, but our withdrawal agreement from the European Union, and therefore our adherence to it remains incredibly important, but that because it is a living document, it is able to flex and evolve to recognise that the world that we see today, the world of asylum and the international context of that, is different from how that existed when the Treaty of London was first very strongly championed by Winston Churchill in the 1950s. And therefore I am very much persuaded that the Minister is correct in the way that he seeks to reject these amendments, but to acknowledge the spirit and the tone of what is being said behind them. Madam Deputy Speaker, I'd like to move on to address some of the issues that arise in Amendment 7B. And again, I am persuaded by what the Minister has said about that. But I do think that there is an issue which is a long-standing one in respect of the way in which unaccompanied children are treated. The Children Act 1989 sets up the legal framework, and that sets out in some detail that a child who is not accompanied by a person who has parental responsibility for them, by operation of law becomes the responsibility of a local authority. And whether that local authority goes through any process at all to bring that child into the care system formally, for example by seeking a care order or not, it remains the responsibility of the local authority where that child arises to take care of them. And if they return later on in early adulthood and are able to make a case that they have been present in that local authority as a child, then they are also entitled to care leaving responsibilities from that local authority under the Leaving Care Act 2000. And the reason why that is significant is that it does set up a potential conflict between the impact of immigration legislation and the impact of Department for Education Children Act legislation. Now, we know that this has been an issue, and I know there's at least one other member who represents the The same local authority which sits in a substantial part of my constituency, where Heathrow Airport means that a single local authority has had very large numbers, the London Borough of Hillingdon, of unaccompanied children coming in over the years, has been responsible for carrying out age assessments and often challenged by those young people and their advocates in a way that can result both in judicial reviews going in one way or another, with significant cost implications to the public purse and safeguarding risks both to children and to others that they might be with, where those may arise. So I'd simply urge the Minister to make sure that when pressing the point that it remains the Home Office that is the decision maker as to whether a person is a child or not, that as far as the law is concerned, it is a Merton-compliant, so-called Merton-compliant age assessment that is the gold standard for determining whether a young person is an adult or not. And whilst we've had a lot of suggestion that we could use scientific methods such as X-rays, the fact remains that those provide a very wide age range for a young person, that for the purposes of determining whether they were just under or just over 18, which is the relevant issue for the Children Act responsibilities, are useless. And that is why it is the Merton-compliant age assessment process that is so important. So, whilst I support the Minister in saying we need to reject that amendment, we do need to ensure that the process that we have in place, in particular, does not put local authorities in an impossible position where they are judicially reviewed for their failure to provide services which they are obliged to under the 1989 Children Act or the Leaving Care Act to an individual who has been removed or subject to other immigration control by a decision of the Home Office. Because we could certainly open up the prospect of what is in effect proxy judicial reviews to challenge the government's immigration position by using the Children Act or the Leaving Care Act legislation. Finally, Madam Deputy Speaker, I just wanted to address two other points which arise. One in respect directly of the amendment, and the other in response to the point that was made by, I think, the member for Glasgow Central about what in practice happens to people. It is, in my view, very welcome that the government has brought forward what it has to say about the treatment of people who are victims of modern slavery. And again, many of us will have had individuals in our constituencies who've been affected by that, both the impact it has on our local public services, our police forces, our local authorities, our housing authorities of identifying people and providing appropriate support, but also very keen to ensure that given the progress that we've made in this House on that issue, that we do not fall back through the impact of other legislation. And I think we'll be watching closely to ensure that the report that's proposed as an alternative to the Lord's amendment on that is going to work in practice as well as the Minister has set out it will. But just finally, the point has been raised about what happens in practice by a number of members. And I think many of us will be conscious that this has, again, a very significant impact on local authorities, going back to the 1948 National Assistance Act, which says that a local authority must provide support to someone within its area who is destitute, regardless of any other considerations about their status. Now, in practice, that is the reason why local authorities will be required to step in and provide emergency temporary accommodation to families with children in particular, where their asylum claim has been refused, but they remain here in the United Kingdom. And that means that the local authority, whilst it is not ever going to be housing those people in social housing because those individuals have no entitlement to it, they will be accommodated in hotels, in hostels and other types of accommodation, which in turn creates additional housing pressure locally. So it is incredibly important that we make sure, as the government has set out, that this system not just works well at making the decisions early on, but it ensures that there are effective processes so that those who should not be in the United Kingdom are removed in order that that accommodation and that those other services are available for those with an entitlement to be here.
Yes. Yeah.
Order. It will be obvious to the House that we have just over an hour left for the remainder of this debate, and I hope that we don't have to have a time limit, but if speeches were around 7 minutes or so, then everyone will have an opportunity to make their points. The speeches so far have not been too long, they've been perfectly reasonable, but I'd like to keep to that. Around 7 minutes, please. Dame Diana Johnson.
Thank you, Madam Deputy Speaker. We are now on the final stages of the legislative journey of the Rwanda scheme, announced, as my honourable friend on the front bench said, 2 years ago. What we do know is that £370 million is already committed to the Rwanda scheme. No individuals have yet been sent to Rwanda, and the Rwandan government are reportedly wanting to pause the scheme after the first tranche of removals. So the question of how this policy will meet the government's objective of deterring small boat crossings remains pertinent, especially as we've heard a record number of individuals have made the dangerous channel crossing during the first 3 months of this year. So I want to turn to each of the Lord's amendments. I also just want to say to the Honourable Member for Stone, who's not in his place, that when I went along to the other place to hear the debate on the Rwanda bill, the Safety of Rwanda bill, I was very impressed with the debate, with the points that were being raised by the other place. And I think to say that the House of Lords needs to calm down a bit and these are ridiculous amendments is really doing a huge disservice to what the revising chamber can provide for this part of Parliament in ensuring that when they think we've made mistakes, when they think things need to be looked at again, that they give that opportunity to us. So turning to Lord's Amendment 1B, this is a modified version of the original Lord's Amendment 1, and the original added a requirement to maintain full compliance with domestic and international law. So while Amendment 1B, which the other place had proposed in lieu, now sets out a requirement to have due regard for domestic and international law. And moving 1B on the 20th of March, the Noble Lord Coker said, "We've put this forward because the bill that your lordships are discussing now explicitly disapplies aspects of domestic law and disapplies aspects of international law. As I made plain in the previous debate on the Lord's Amendments, if the government is so confident that the Rwanda scheme will be fully compliant with domestic and international law, it should really have no objection to this amendment." And turning to Lord's Amendments 3B and 3C, which are around treaty implementation and monitoring committees, Lord's Amendment 3B and C are modified versions of the original Lord's Amendments 2 and 3 respectively. Amendment 3B, like the original Lord's Amendment 2, states that the Rwanda will be a safe country when the arrangements provided for in the Rwanda Treaty have been fully implemented and for so long as they continue to be so. The wording has changed slightly and there's no longer a reference to the arrangements in the treaty being adhered to in practice, but the effect is the same. Lord's Amendment 3C, like the original Lord's Amendment 3, sets out what full implementation would look like and gives the Independent Monitoring Committee a significant role. Unlike the original Lord's Amendment, there is no requirement on the Secretary of State to consult the Monitoring Committee every 3 months. Instead, Amendment 3C states that the treaty will cease to be fully implemented if Parliament decides, on the advice of the Monitoring Committee, that the provisions of the treaty are no longer being adhered to in practice. So in moving Amendment 3C, the Noble Lord Hope of Craighead said it was an attempt to respond to a point made by the Right Honourable Member for Kenilworth in the Commons debate on the 18th of March, and he said that my Amendment 3C in lieu does my best to make it clear that the authority lies with Parliament and not with the committee. Now, the Home Affairs Select Committee has argued that the House of Commons be given an opportunity to debate the treaty prior to ratification in light of how critical its implementation is to the Rwanda policy. Given that this opportunity to scrutinise the treaty was denied, Amendment 3B would at least provide some reassurance to members that its provisions will be implemented and applicable to anyone relocated to Rwanda, while Lord's Amendment 3C would enable Parliament to review the treaty's implementation and respond to facts on the ground if and as they change. These Lord's Amendments speak to the practicalities of implementing the Rwanda policy and how too often, sadly, the government have sought to skate over them. So take the issue of an airline. For this policy to function, the government has got to be able to transport people to Rwanda, yet ministers have still not confirmed they have secured an airline, with Rwanda's own state-owned airline reportedly declining a request to use their planes. Then there's the issue of where migrants will live if they're deported to Rwanda, if they're sent to Rwanda. Recent reports suggest the majority of homes on a new Rwandan housing estate, initially earmarked for migrants relocated from the UK, have been sold to local buyers. And these are not moot points, these are the kind of practical details that will determine whether the scheme works and whether it works safely. So in the absence of prior scrutiny of the treaty, the House of Commons, I think, must be allowed to assess its implementation and act on the findings. Now just turning to Lord's Amendment 6B around legal challenge. This is a modified version of the original Lord's Amendment 6, and like the original, it deletes Clause 4 of the bill, allowing much wider grounds for legal challenge. Like the original amendment, it says that a court or tribunal may prevent or delay the removal of a person to Rwanda, but unlike in the original, it adds, providing such prevention or delays for no longer than strictly necessary for the fair and expeditious determination of the case. The Home Affairs Select Committee has always recognised that the opportunity for appropriate legal challenge is a necessary part of an effective and fair asylum system, which is why I believe this amendment has significant merit. Turning to Lord's Amendment 7B, this is a modified version of the original Lord's Amendment 7. The original amendment disapplied Section 57 of the Illegal Migration Act in its entirety, meaning that people claiming to be children could appeal against a decision that they are over 18. Lord's Amendment 7B instead inserts into Section 57 of the Illegal Migration Act a new subsection. And in moving Amendment 7B, the noble Baroness Leicester explained, the amendment in lieu is much more modest and in effect meets the Commons' formal objection to the original amendment. It would permit an age-disputed child to be removed to Rwanda with a pending challenge on a limited basis, but only if a proper age assessment has first been carried out by a local authority. During its Channel Crossings inquiry, the Home Affairs Select Committee heard examples of safeguarding processes failing across various parts of the asylum system, including cases of children being mistaken for adults, for which is why I believe that the government must look again at this amendment. Lord's Amendment 9 on modern slavery adds a new clause to the bill to create an exception relating to the removal of victims of modern slavery and human trafficking. The new clause states that a person with a positive reasonable grounds decision from the National Referral Mechanism must not be removed to Rwanda until they have received a conclusive grounds decision, and that a person with a positive conclusive grounds decision must not be removed without the decision maker considering the effect on their physical or mental health or safety. The government have proposed Amendment A in lieu of Lord's Amendment 9, and it would require the Secretary of State to publish an annual report about the operation of the Act as it relates to modern slavery and human trafficking provisions in Article 13 of the Rwanda Treaty. So again, the Home Affairs Select Committee's recent report on human trafficking expresses our concerns that the government is prioritising irregular migration issues at the expense of tackling human trafficking. Human trafficking is not an immigration offence, it is an exploitation offence, and the two must not be conflated. Lord's Amendment 9 would provide a vital safeguard for victims of human trafficking, and I hope again the government will look at that. Finally, Lord's Amendment 10B. This is a modified version of Lord's Amendment 10, and like the original amendment, it provides an exemption for people who supported our armed forces overseas or who have otherwise been agents or allies of the UK overseas. Lord's Amendment 10B includes a new subsection which states that a person who intends to rely on this exemption must give the Secretary of State notice as soon as reasonably practicable to allow prompt verification of available records. In moving Amendment 10B, the noble Lord Brown said, "We are told that men who brave death, courted injury and are forced into exile as a result of assisting our armed forces in fighting the Taliban are now to be punished for arriving here by irregular routes, even where, owing to wrongful refusals on our part or possible malfeasance on the part of the Special Forces, they have been compelled to take these routes in the first place." And we know that currently families from Afghanistan who helped our armed forces and subsequently fled to Pakistan are at imminent risk of deportation back to Taliban-controlled Afghanistan. This is despite ministerial reassurances that a route for eligible separated Afghan families to come to the UK would be established. It seems to me and many others that the UK has a moral duty to offer sanctuary to those brave Afghans who put their lives on the line to support our troops and who are now face persecution as a consequence. The idea that we would attempt to outsource this duty is frankly shameful. The Lord's Amendment before us today would go some way to providing safeguards and assurances that the UK will uphold its moral and legal obligations in the implementation of the Rwanda policy.
Sir Robert Buckland.
Thank you, Madam Deputy Speaker, and I will try and beat the record, the extraordinary record of my honourable friend, the member for Stone, who spoke for a princely 2 minutes today. I'm grateful to him for setting that new record, his personal best, I think. I will, in dealing with the amendments in turn, first of all, return to a theme that I have warmed to in the past about Clause 1 of this bill, which I think is an abomination. It's exactly the worst sort of legislative drafting that we should be discouraging, because it at best is declaratory legislation, which I think is never helpful, and at worst sets up all sorts of potential legal arguments. I think the attempt by the Lords to amend it further probably makes the situation even worse, which is why I will not be supporting Amendment 1. Having said that, I will give way to my honourable friend.
Especially to hear my right honourable friend. And I was delighted to hear what he just said. At last he's seen the light.
I've always walked in sunlight, Madam Deputy Speaker. There's others, perhaps, who have walked through a veil of shadows. But we will draw a veil over that. What I would say to my honourable friend, in the spirit of his helpful intervention, is that on a previous occasion I mentioned to him how I thought that Clause 5 of this bill was unnecessary. It's even more necessary now, because the reforms that I referred to in a previous speech on this bill about Rule 39 have now, of course, been clarified by practice direction. And the threshold that the European Court will apply will be, again, a much higher one. And I think, therefore, the occasions where we could see it invoked in the Rwanda case will be vanishingly small, because, in fact, non-existent, because it seems to me that any harm that might be adjudged to have been caused is clearly revocable in the form of a return of those individuals from Rwanda in the first place. That, frankly, should have been the position last time round. I think that the reforms of the European Court make it even clearer. But that makes, I think, a very powerful general point which supports the excellent arguments made by my honourable friend from Ruislip Northwood about the direction of travel of the court. And I agree with him strongly about the recent climate change decision. I think it was a wrong turn. I think we should be going back very much to fundamental human rights, not talking about socio-economic rights or trying to create everything into some form of right. Surely it is better to legislate in the form of statutory duty and obligation by public bodies, rather than creating nebulous rights that then become the province of the courts. But herein lies the difficulty I think we still encounter in the second batch of amendments, namely the amendments that now form in the form of the Lord's Message, amendments 3, B and C, which I am still minded to support. Whether we like it or not, the Supreme Court was in a position where it assessed evidence and substituted its own view for that of the decision makers. Now, the noble Lord Howard have made a very powerful speech in the other place about the wisdom or otherwise of going down that road. I agree with a lot of what the noble Lord said. I do not like it when I see courts of higher record, in effect, relitigating matters of evidence, which is what the Supreme Court did. But that is the situation that we live in. That is why this bill has come forward. And my abiding concern about a deeming provision, although it is not unprecedented, I accept, is that it should be matched by reality. And that is why I do press my right honourable friend to answer some of the points made in the other place about the progress being made by the government of Rwanda to legislate not only its treaty obligations, I know it's a modest system, so the treaty is already in force, but to carry out the obligations that it agreed to in the treaty, namely the reform of its appeal system, the use of trained advisors, all the measures that will go a huge way, not just to reassure me, but to reassure any court that might be seized of this matter in the near future, that indeed all is proceeding well. And indeed, I have to say that the noble Lord, the Lord Advocate, the Scottish Lord Advocate, seemed to concede the point in the other place about there needing to be full treaty implementation before the treaty itself is ratified. And if that is the case, then I really think we're arguing over very little at all here, which is why I still commend those particular amendments. Now dealing then with the next questions, Madam Deputy Speaker, which relates to the arguments, I think, again, very trenchantly put by my honourable friend from Ruislip Northwood. I agree with him about the danger of proxy judicial reviews based upon the Children Act and care legislation. I do think we need to take very great care about that, but I, like him, am not persuaded that there is merit in supporting the Lord's amendments on that particular issue. And I am also encouraged, though still concerned about the modern-day slavery position. I'm encouraged that the government here, alone amongst its response to the other Lord's amendments, has come up with an amendment in lieu, which I am prepared to support, bearing in mind the very sensitive and important nature of this legislation, the need to avoid us riding a coach and horses through the progress that we've made in terms of this country's leadership on modern-day slavery. But I am prepared to give him the benefit of that doubt and to support it. But latterly, I still have concerns about a class of people who served our country, who endured great danger in Afghanistan, who still find themselves in danger in a third country, namely Pakistan, and who may well fall foul of, I think, an entirely unintended consequence, but one that could occur as a result of this legislation, however well-intentioned it may be. And my abiding concern about those people who have made a sacrifice for our country, I'm afraid, remains, which is why I'm still not persuaded on 10B. I do think the government has moved. This is the iterative process that we are in with the Lord's messages, and I agree with the Honourable Lady, the member for Hull North, in reminding us of the invaluable role that the deliberative chamber has in making sure that legislation is tested and that it is up to the level of events. And I don't think we should ignore what was said in the Lords about the evidential situation in Rwanda. That is the reality. And that is why I think that when we pass legislation here, we should do everything we can to avoid legislative fiction. It's not good law. It creates a glass jaw, frankly, that can be broken by litigation and by judicial challenge. And once again, the courts are back in a position where I don't think any of us, least of all Conservative constitutionalists, want to see them put. Let's legislate with care on this matter, and let's get it right. Thank you.
Just to just to remind the House that due to the pressure of time, the debate on hospices is now not taking place tonight, and I know that there's a lot of interest in that, so we will hope that that will be reprogrammed as soon as possible. And also that just to remind everybody that we're trying not to put a time limit on, but Madam Deputy Speaker did encourage 7-minute contributions, no more, so please could you tailor your speeches accordingly. Beth Winter.
Deputy Speaker, I rise in support of the Lord's amendments, which I will be voting to retain this evening, and I will keep my comments brief. And in particular, I want to express the need for the House to support Lord's Amendment 6B. It has already been discussed how, under the Government's preferred wording of Clause 4, a court still cannot consider the risk of refoulement by Rwanda in contravention of any of its international obligations, even though this was the very risk highlighted by the UK Supreme Court. Lord's Amendment 6B reinstates the protection that the Government wishes to remove. The Amendment 6B would omit Clause 4 and replaces it with a clause which seeks to restore the ability of decision makers to consider whether Rwanda is a safe country, and restores jurisdiction of domestic courts and tribunals to grant interim relief, a temporary injunction preventing a removal. I wanted to note in particular, during the most recent Lord's stage, the previous version of the amendment rejected by this House was changed. It now adds the stipulation that any interim relief be for, and I quote, no longer than strictly necessary for the fair and expeditious determination of the case. The lead member on this in the amendment in the other House, Baroness Chakrabarty, said, "This is a significant concession and that it is a genuine legislative olive branch to the Executive." Mr Deputy Speaker, the Executive, the Government, should accept that it is an improvement to the bill, and rather than neutering the powers of decision makers or the courts, it will allow for better decision making in the asylum process. Mr Deputy Speaker, it remains my firm view that the Rwanda bill is an affront to international law, human rights and the rule of law more widely, and it really does set a dangerous precedent to other nations who wish to ignore the law, cause harm, demonise and exploit vulnerable people who are in need, desperate need of our... Yes, I would give way.
I thank my friend for giving way. She will be aware that there are many people all over Europe, particularly in the Council of Europe, that have expressed grave concern about this piece of legislation, which in effect is outsourcing our international obligations under all aspects of humanitarian law. And if we pass this legislation into law, many others will follow, and Europe will be turning its back on refugee problems it has often helped to create.
Yes, I fully agree that this does really set a dangerous precedent. And I just wanted to add that I'm pleased to say that the disgracefulness of this piece of legislation is recognised in Wales by the Welsh Government, who have withheld legislative consent on similar draconian pieces of legislation and describes this bill as cruel, inhumane, unworkable and unethical, and really does set a significantly horrific precedent for other countries to follow. And I am so proud that in Wales we are looking to establish a nation of sanctuary where we welcome, understand and celebrate the unique contribution that asylum seekers fleeing horrific situations can contribute to our country of Cymru. So this bill is an assault on our checks and balances, on our scrutiny of those powers, and quite frankly is unamendable and should be thrown out wholesale. But given that that is unlikely to happen, in a true attempt to make a bad bill less bad, I will support Amendment 6B and the other amendments before the House this evening. Diolch yn fawr.
Tim Farron. The Deputy Speaker. I rise to support the amendments that the Government is seeking to overturn from the other place this evening. The issue of mass migration of people, refugees, people fleeing from the consequences of climate change, people maybe seeking just a better life for themselves, people fleeing from war and persecution is a huge and serious global problem, and this bill is a deeply unserious response to it. The Rwanda bill has become, if you like, a byword for Conservative incompetence, for waste of public money, and indeed, at times, deep and unpleasant cruelty. The Minister didn't take any interventions, as his entire right to do, I think basically because he was suggesting he'd heard all this before, and in more detail, more explicitly, the Right Honourable Member for Stone said this was just a debate all about repetition. Too right, it's all about repetition. If the Government keeps coming back here with ridiculous legislation, we'll keep opposing it. And the Lords are well within their rights. As somebody who passionately believes in democratisation of the House of Lords, nevertheless,
This is a piece of legislation that was not in the government's manifesto at the last general election, and which the House of Lords has every right to seek to amend and to scrutinise. And the amendments that we're looking at are hardly deeply radical and shocking. I mean, so Amendment 1B, for instance, asks that the government and this legislation should have due regard for international and domestic law. That's colossally revolutionary. No, it isn't. No, the fact that the government has somehow a problem with any having due regard for international or domestic law is deeply problematic to me, and should be deeply problematic to most people who would consider themselves to be conservative. We think about the issue of safety. There are a variety of amendments here in front of us, 3B, 3C, 6B, which allude to this and which are all important, and I would seek to support all of them. As has been said by others, it is a nonsense for this government, or any government, to seek to try and make something so just by saying that it is. We've had many other colourful examples as to what other things we could just will to be the case. I declare Blackburn Rovers back in the Premier League and Chris Sutton and Alan Shearer both back in their 20s. This is not how the world works. And we must recognise that if the government now believes it has evidence to suggest that Rwanda is a safe place, fair enough. Present the evidence to the court. That's what you do if you're behaving like a normal, constitutional, conservative, or indeed a constitutional Democrat of any other kind. With regard to Amendment 9B, which talks about the issue of protecting victims and potential victims of modern slavery, the former Prime Minister, the Right Honourable Member for Maidenhead, is rightly proud, and this government should retain some pride in the modern slavery legislation. This is an amendment that would not actually prevent the Rwanda programme taking place. It would just prevent those people who are potentially at risk of modern slavery from being part of that deportation. There is no reasonable justification for any reasonable government to object to Amendment 9B and 10B, like other people in other honourable and right honourable members in this place and outside of it at this moment. I have spoken to people who escaped Afghanistan, who had been helping the police against the Taliban, and indeed helping UK armed forces against the Taliban, but were left behind. And the only way they could seek safety was via irregular routes and eventually to cross the Channel and end up in the United Kingdom. 10B allows the individual I'm thinking of that I met in Barrow a few months ago, who, by the way, is being well served by my honourable friend and neighbour, his member. It would allow him the right to be here and not to be removed. It's about Britain doing the right thing and maintaining its obligations to people who put their lives on the line to protect us and to protect our forces. But I said this is a deeply unserious bill to deal with a massively serious problem. The least serious thing that was said today by the Minister was that this bill constitutes any form of deterrence. The simple fact is that 1 in every 200, if the government gets its own way and everything goes absolutely perfectly, 1 in every 200 asylum seekers here might just get sent to Rwanda. What nonsense. The idea that someone has fled the murderous tyrant Isaias Afwerki in Eritrea, left that country because they were going to be conscripted to murder their own people. They've crossed the hellhole that is Libya. They've been across the Mediterranean, for pity's sake. They've gone across the rest of Europe. They're faced with what? A relatively small body of water to cross to get to the United Kingdom and a 0.5% chance of being sent to Rwanda. That deters anyone. Who is the Minister trying to kid? This is a ridiculous waste of money. The money spent on Rwanda so far could have done many things, one of which would have been employed more than 6,000 caseworkers to help remove those people who are not genuine asylum seekers. That would actually be a deterrent. Instead, we have this nonsense. I better not, because I'm taking up much time. I'll simply finish with this. I'm sure I'm going to agree with whatever the honourable gentleman would have said. I simply want to say this, that this is a bill riddled with pretence. The pretence, above all, that this would be a deterrent to anybody. A ridiculous waste of taxpayers' money, deeply uncruel. If Rwanda is a safe place, it will deter no one from coming here and then being sent there. If it is an unsafe place, no decent government would ever propose to send anyone to it. You cannot have it both ways. You have it neither.
Thank you very
very much, Mr Deputy Speaker. This bill casts a shadow over the reputation of this place and over our country as one where the rule of law is valued and respected. It is a matter of grave concern that the government seems determined to ignore the many legal experts and human rights organisations that have voiced serious and fundamental concerns about this bill. As Lord McDonnell of Salford, a crossbench peer and former Permanent Secretary at the Foreign Office, set out clearly in the press over the weekend, the bill declares as fact that Rwanda is safe enough to provide shelter for vulnerable people fleeing persecution in their home countries, and that not only must British courts accept that Rwanda is safe, they cannot question that assertion, even in the light of new evidence that Rwanda may no longer be safe. Surely all of us in this place know how quickly political change can arise in any state. It is nonsensical for the government to make such a declaration about the safety of Rwanda, but to do so when the impact on vulnerable people has the potential to be so severe and affect their fundamental human rights and their safety is irresponsible and reckless. Yeah. Amnesty International UK are among those urging the government to drop this divisive and dangerous piece of legislation. They have called the bill an affront to international law, human rights and the rule of law more widely. And they have warned that, if passed, it will leave the UK in serious conflict with its international human rights obligations, send a dangerous signal that other nations are free to show similar disdain for their obligations under international law, and harm people who are powerless, vulnerable to demonisation and readily and cruelly exploited. The Law Society has described the bill as flawed and that it undermines important British values such as the rule of law and protection for victims, damages the UK's constitutional balance and will ultimately prove unworkable while costing the UK taxpayer a great deal of money. They have also highlighted research which suggests that 61% of people think the government should either accept some amendments to the Rwanda policy or scrap it altogether. Liberty has described this bill as a constitutionally extraordinary piece of legislation, adding that in several places its provisions advance into some potentially dangerous positions. For a government to get to this point, to try to put through legislation that human rights experts describe as potentially dangerous is truly shocking. Why is it that the government thinks that it can ride roughshod over international law and human rights? The amendments that we are considering today would, among other things, require the government to give due regard to domestic and international law, a most important principle that no one could dispute, allow ministers, officials and courts to consider whether Rwanda is safe on a case-by-case basis, and remove the risk of unaccompanied children being inadvertently sent to Rwanda. Amendment 6B, for example, would allow the court or tribunal to grant an interim remedy that prevents or delays, or that has the effect of preventing or delaying, the removal of the person to the Republic of Rwanda, providing such prevention or delays is for no longer than strictly necessary for the fair and expeditious determination of the case. Surely any reasonable government would want to ensure it had the power to do this. There is still time for the government to drop this horrendous bill, and I urge them to do so. And I also urge all members across this House who care about the rule of law, our international reputation and the seriousness with which we should address our international responsibilities to support the amendments from the other place and vote against the government's motions tonight.
Very much. Claudia Webbe.
Thank you, Mr Deputy Speaker. The dangers to any nation whose government seeks to put itself above the law and the courts are clear. And the late Tony Benn put it well when he said that how governments treat refugees is an indication how they would treat their own citizens if they thought they could get away with it. This government's contempt for the people of the UK is revealed by the assault on the rule of law that this bill represents. It is also self-evident that a country does not become safe. It does not become a safe destination just because a government declares it so. Human Rights Watch latest analysis of Rwanda is clear that repression of free speech, arbitrary detention, illegal treatment and torture remain widespread. The Noble Baroness Chakrabarty's amendment is an attempt to remove one of the most damaging aspects of this bill and restore the primacy of law above the whims and ambitions of politicians in asylum applications, and to prevent the government simply declaring blanket fashion that Rwanda is safe because they wish it to be and want to deport those fleeing terrible dangers who reach our shores, including let's not forget children. By denying access to a court to challenge the safety of the Rwanda bill as not being compatible with the UK's international obligation is to shame our country. As I have said before, the only real solution to this malignant and discriminatory bill is actually to scrap it altogether. But at the very least, its worst aspects must be mitigated, and that includes the need to restore the jurisdiction of the domestic courts as to the safety of Rwanda and the power to grant interim injunctions, and, at the very least, to look at matters on a case-by-case basis. I therefore support Amendment 6B and all other amendments from the other place, and I urge all honourable and right honourable members in this House to do the same. Thank you, Mr Deputy Speaker.
And following John McDonnell, with leave of the House, the Minister will respond. John McDonnell.
I only want to make 4 brief points, really, and it's based upon my experience in my own constituency. I think at the height of the number of asylum seekers being placed in hotels, I think I had the largest number, and I think I still have. I had 2,500 asylum seekers in my constituency, and I welcome them. I welcome them into our community, and our community as I think, as always in Hayes and Harlington, they've risen to support people in need. So I was proud of the local community. And the lessons I've got from dealing with those asylum seekers, touring around the hotels, dealing with casework. In fact, one of the hotels was actually next to my constituency office. 4 points, really. One is the point that the Honourable Member for Westmorland and Lonsdale made, is that these are desperate people. They are desperate people, and they will not be deterred to coming here, but having experienced what they have experienced back in their home country, and also in the way in which they've travelled here, and the desperate circumstances that they're in both instances. They will not be deterred by this legislation. And it just, for them, they know the same as we do, that this is a political stunt rather than anything else. Certainly.
I thank my friend for giving way on this point. It's been my privilege to visit Calais on a number of occasions over the past few years. And I've had many conversations with people there. They're desperate, they're poor, they're hungry, they're homeless, they're victims of war and human rights abuses, and they're being treated as though they're enemies of the whole community here. They're not. They're people trying to survive in a very difficult world, and our message seems to be the opposite of all the humanitarian law that's been passed into common parlance over the past 70 years.
Sort of follow what my friend has said. The other lesson I've learned from meeting this wide range of asylum seekers is what skills they can bring to our country and how desperate they are to make a contribution. And all they want is for their case to be processed, because the vast majority of them, even those detained in the 2 detention centres in my constituency, the majority will actually win their cases and then be received into the community. The problem that they have is the processing situation means that they have to travel here not through the normal processing, and secondly, when they get here, they're waiting anything up to 2 years just to have their case heard. So I don't think in any way this will deter desperate people from coming in that way. The second point I make relates to the amendment with regard to the assessment of children. The Honourable Member for Ruislip, Kinnock and Northwood is not here, and he made reference to both of us because we're both members of Parliament representing the London Borough of Hillingdon, that has accepted more unaccompanied children than any other borough itself, because of the proximity of Heathrow within our constituencies. We've had a problem with age assessments, and the problem has not been the one that the media hone in upon, which is elderly people being assessed as children. It's the other way around, children being forced through the process of all of this, which actually can be really demeaning and can impact upon their mental health, and then eventually being found to be children, as all the statistics demonstrate. So it's a brutal system, and all this amendment is doing is making sure that assessment is done by those who are experienced in that assessment process, which is local authorities. The third point I want to make, because of my experience with asylum seekers in my constituency, is with regard to Afghans who've come here, who've worked alongside the military within our own military within Afghanistan, and then, again, I believe have been dramatically let down by our own government, left there with their families in desperate plight, often having to go from house to house, hiding, and recognising when they go to house to hide in accommodation in Afghanistan, they're putting that family at risk. And then some of them, the advice that they were given is get to the nearest border. And so they get to the nearest border, one of which is Iran, then they get sent back, or Pakistan, and then they get sent back again. And if they can break through that system and get here, then what happens is they're treated almost like criminals, even though they've often put their lives at risk in supporting this country. Now, the Minister has said today he'll be reviewed. There's a review of the ARP scheme going on, and that will be taken into account, and that seems the solution. All I can say is that review needs to be undertaken immediately, but whilst it's going on, can I urge the government to exempt those people who've served us in Afghanistan from this process, at least whilst that review is taking place. Otherwise, we'll be sending people back, sending people to Rwanda who I think we deserve some loyalty to, but also who have experienced quite traumatic dangers to their lives in serving us. Final point I make is this. I heard one person on the radio this morning, a Conservative MP, justifying this overriding of domestic law and the courts themselves as though this was some rebalancing between the executive and the courts. It's not a rebalancing, it's riding roughshod over the system of law that we have in this country, of respect for the decisions of the courts themselves. And I just say that I give a warning to the government and the party opposite. This actually places an awful lot of power, sets a precedent of placing an awful lot of power in the hands of the executive. Just think what a government with a huge majority could do in using that precedent in the future. And you know, that unbalancing that's happening at the moment is one in which it places the ultimate decisions between what is reality and unreality in the hands of a government. I think people will live to regret setting that precedent if we're not very, very careful. This bill is a rubbish bill. It should be thrown out. And I congratulate those members in the House of Lords and the other place that are doing their best to at least bring some sense towards it. Regrettably, we won't be able to throw this bill out, but at least what we can do tonight is vote for these amendments and send a message back to the other place, is keep fighting on this bill, because at least they have some sense of reality of what these people who seek an asylum in this country are experiencing.
Minister.
Mr Deputy Speaker, with leave of the House, I would like to remind the House that I opened by saying that we were not quite at the point of completing each other's sentences, but perhaps, Mr Deputy Speaker, we are there now. My honourable friend, the member for Stone, hinted that I might be in danger of repeating myself, and so I'll make sure that I keep my remarks to the point. Can I thank honourable and right honourable members for their contributions? I thank, as always, the honourable member for Aberavon for the way that he conducts himself. He reminds us that he is an inveterate optimist, as perhaps you have to be sitting on the Labour benches. But it's right to say that it has been a good-natured debate, despite some uncharacteristic heckling from the Shadow Secretary of State. And I had some gentle chiding from the honourable member for Westmorland and Lonsdale, who gently chided me for not giving way. But I was pleased that I didn't give way to the honourable member for Brent North, not least because he said his intervention was in relation to Amendment 2, which doesn't appear on the order paper, it's not on the list, and it's not being debated. The honourable member for Glasgow Central, I thank her as always for her contributions. She'll be pleased to know that we disagree again. That will reassure her, but I'm sure her campaign will continue. My honourable friend, the member for Ruislip, Northwood and Pinner, as always, made some serious points. Just on his point in relation to local authorities, and it's also relevant to the right honourable gentleman, the member for Hayes and Harlington's point. I met recently with the leader of Hillingdon Council, Councillor Ian Edwards, and I discussed some of these issues and some of these pressures. I'm very grateful to my honourable friend, the member for Ruislip, Norwood and Pinner, for his contributions. He tempted me to go down a certain path that's unnecessary, Mr Deputy Speaker, in relation to the ECHR and a recent judgment. And indeed, my right honourable learned friend, the member for South Swindon, also tempted me to go down that certain path. But I'm going to resist that temptation for the time being. The right honourable lady, the chairman of the Select Committee, she mentioned a desire to debate the treaty, but Mr Deputy Speaker, may I just gently suggest to her that we've had ample opportunity to debate the treaty, not least as part of the proceedings in relation to this bill. But may I respond to my right honourable learned friend's points in this way? He mentioned a temptation for amendments, and a liking indeed, for amendments 3B and C, and he asks me what progress has been made. Can I reassure him that progress has been made? And can I reassure him once again that the government will only ratify the treaty once we agree with Rwanda that all necessary implementation is in place for both countries to comply with their obligations under the treaty. He also rightly asked, as did other members, honourable and right honourable from across the House, about Amendment 10B. And I merely repeat the point that this government recognises the commitment and responsibility that comes with combat veterans, whether our own or those who showed courage by serving alongside us. We will not let them down. Mr Deputy Speaker, I invite all right honourable members to join us in the government lobbies. This will allow us to get flights off the ground, to disrupt the business model of the people smugglers who are exploiting vulnerable people. I beg to move.
Thank you very much. I am expecting several divisions. The question is that this House disagrees with the Lords in their Amendment 1B. As may that opinion say aye. Aye. Or the contrary, no. No! Division, clear the lobby. The question is that this House disagrees with the Lords in their Amendment 1B. As may that opinion say aye. Aye. Or the contrary, no. No. Tell us for the ayes, Mike Wood. Amanda Soloway, tell us for the noes. Andrew Weston, Tonia Antoniazzi. Order.
The ayes to the right, 315. The noes to the left, 250.
Thank you. The ayes to the right, 315. The noes to the left, 250. So the ayes have it. The ayes have it. Unlock. We now come to Lord's Amendments 3B and 3C. Minister, to move the motion to disagree formally.
To move.
The question is that this House disagrees with the Lords in their amendments 3B and 3C. As many of that have been say aye. Aye. On the contrary, no. No. Division, clear the lobby. Order. The question is that this House disagrees with the Lords in their amendments 3B and 3C. As many of that have been say aye. Aye. Contrary, no. No. Tell us for the ayes, Amanda Soloway, Mike Wood. Tell us for the noes, Tonia Antoniazzi and Andrew Weston. Order. Order.
The ayes to the right, 317. The noes to the left, 246.
Thank you. The ayes to the right, 317. The noes to the left, 246. So the ayes have it. The ayes have it. Kinnock. Order. Order. Under the programme order of the 18th of March, I must now put the questions necessary to bring to a conclusion proceedings on the Lord's message. We now come to Lord's Amendment 6B. Minister to move the motion to disagree formally. The question is that this House disagrees with the Lords in their Amendment 6B. As Madam say aye. Aye. Of the contrary, no. No. Vision, clear the lobby. Order. Order. The question is that this House disagrees with the Lords in their Amendment 6B. As Madam say aye. Aye. Or the contrary, no. No. Tell us for the ayes. Mike Wood and Amanda Soloway. Tell us for the noes. Andrew Weston and Tonia Antoniazzi. Order.
The ayes to the right, 319. The noes to the left, 249.
Thank you. The ayes to the right, 319. The noes to the left, 249. So the ayes have it. The ayes have it. Unlock. We now come to Lord's Amendment 7B. Minister to move motion to disagree formally.
Move.
The question is that this House disagrees with the Lords in their Amendment 7B. That up and say aye. Aye. The contrary, no. No. Vision, clear the lobby. The question is that this House disagrees with the Lords in their Amendment 7B. As many other members say aye. Aye. Contrary, no. No. Tell us for the ayes, Amanda Soloway, Mike Wood. Tell us for the noes, Tony Antoniazzi and Andrew Weston. Order! Order!
The ayes to the right, 319. The noes to the left, 249.
Thank you. The ayes to the right, 319. The noes to the left, 249. So the ayes have it. The ayes have it. Unlock. 2 more to go. We now come to Lord's Amendment 9, and I call the Minister to move the motion. To move. The question is that this House insists on its disagreement with the Lords in their Amendment 9, but proposes Amendment A in lieu. As many of that opinion say aye. Aye. Of the contrary, no. No! No vision. Clear the lobby. Order. The question is that this House insists on its disagreement with the Lords in their Amendment 9, but proposes Amendment A in lieu. As many of them say aye. Aye. Contrary, no. No. Tell us for the ayes, Mike Wood, Amanda Soloway. Tell us for the noes, Andrew Weston, Antonia Antoniazzi. Order. Order.
The ayes to the right, 320. The noes to the left, 246.
Thank you. The ayes to the right, 320. The noes to the left, 246. So the ayes have it. The ayes have it. Unlock. And finally, we now come to Lord's Amendment 10B. Minister, to move motion to disagree. Paul.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 10B. As many of that opinion say aye. Of the contrary, no. No! Vision, clear the lobby. Order. Members could resume their seats, please. The question is that this House disagrees with the Lords in their Amendment 10B. As many of you say aye. Aye. On the contrary, no. No. Tell us for the ayes, Amanda Soloway, Mike Wood. Tell us for the noes, Tony Antoniazzi and Andrew Weston. Order. Order.
The ayes to the right, 312. The noes to the left, 253.
Thank you. The ayes to the right, 312. The noes to the left, 253. So the ayes have it. The ayes have it. Unlock. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to certain of their amendments. That Michael Tomlinson, Scott Mann, Kieran Mullen, James Sunderland, Stephen Kinnock, Colleen Fletcher and Alison Thewliss be members of the committee. That Michael Tomlinson be chair of the committee. That 3 be the quorum of the committee. That the committee do withdraw immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 1B, 3B, 3C, 6B, 7B and 10B, that Michael Tomlinson, Scott Mann, Kieran Mullen, James Sunderland, Stephen Kinnock, Colleen Fletcher, Alison Thewliss be members of the committee, that Michael Tomlinson be the chair of the committee, that 3 be the quorum of the committee, and that the committee do withdraw immediately. As many other people say aye? Aye. I say no. I think the ayes have it. The ayes have it. That concludes consideration of the Lord's message relating to the safety of Rwanda Asylum and Immigration Bill.